Are you guys ready to do this? Okay. I don't need to do housekeeping because you know more about your house than I do. So if you feel like getting up and making yourself more comfortable at any point, go ahead and do that. This is supposed to be more interactive. So as we go through this, if there's something that you want to share from an experience related to the point in the topic that we're on, or you want to ask about it, feel free to do that at any time. If it's not related to what I'm talking about, I love you. We'll talk about it later. Okay? That way everybody else can keep moving along too. So feel free to just interact all the way through this. It'll be a lot more fun anyways. A couple of notes as to what you've got. Okay, so first of all, there is a response card here. At the end of this, if you want any follow-up from me, you can indicate on this. And then I'll follow with you. And you'll see how and what and why as we get through this. If you don't ever want to hear from me again, don't give it to me. I'll leave you alone, I promise. In addition to that, my card is in here. If you're like, I'd rather have control, I'll call you if I want help. You can do that. And then a copy of all the slides that we're going to kind of journey through is right here. And you can take notes next to them. I will tell you that there are some slides in this that we are not going to use because this PowerPoint is typically used throughout Oregon and Washington, and there's some slides that are more Washington-specific that don't apply down here. So that's one of the reasons why we won't get into depth on all of them. In addition to that, we're not necessarily going to hit everything verbatim on each slide. Okay? So don't hold me to that when we get to them, and it'll go really good that way. So a little bit of background, because sometimes it helps to know who you're talking with or listening to determine if you want to stay here until 5 or if you'd rather go outside and enjoy the sun and the breeze. My background was phenomenally woven together by God about 3 years ago in this role. I wasn't looking to do it. Prior to this, my wife and I moved out here in 96 from Colorado after a couple years of being married and needing to hit the reboot button. God had redeemed me on the journey out, literally, by my marker 181 on Highway 84. And started out here in wealth management, did mortgages for very affluent people, and then became a relationship manager with a Fortune 500 company and oversaw the transition of wealth from one generation to the next within families. Had some phenomenal clients here, nationally, internationally, was having a ball. And along the way, my heart started changing. I was having a great time, but it wasn't quite the same thing that I felt like I wanted to do. And so the Lord began this process, this journey of getting me prepared to join him in ministry. I didn't know what it was going to look like. And it turned out to be shepherding. So I pastored a few churches. And then at the conclusion of helping this last church scatter and give themselves away because they weren't going to continue as they were, I was brought into the role on staff with the foundation, which I'd been on the board of while I was pastoring. And so now I'm in this unique role where I've shepherded and I've been in finance, and now I'm in this role with the foundation where they kind of get to merge a little bit. And so that's a little bit about me who's in front of you. And I'm not an attorney. I'm not a CPA. I'm much more of a generalist, and I look at things from a redemptive standpoint of how our life could be and why we get to do what we get to do now. So as far as some of the technical specifics, I'll touch on stuff, but we'll get smarter people to handle it in a personal situation. Is that fair? Okay. So we can go to the next slide. You heard all this morning because you all were here for one of the two services, correct? Okay. Well, then we're not going to get back into this, but the main reminder for us as we move through this is most people find the subject of death and therefore things related to it not all that encouraging, but we don't have to because of the gospel. We were intended to steward everything to his glory and the good of others. And even that journey that takes us through death can be beautiful and special when we are gripped by the reality of the gospel. We see it as the next step in greater intimacy than we presently have with God, because all those hindrances that we currently wrestle with get wiped away through that journey. We get to see him face to face and enjoy him, and we realize that he's got everything taken care of for us because of his goodness and generosity. We'll find that we're free to make some decisions regarding the people and the things that he's placed in our life that will show how wonderful he is to them and the world when we die. And we get to make those decisions now. We get to. This isn't a have-to thing. We get to, right? And so this discussion about estate planning, this is to be worshipful. And you can fast forward a couple slides. Most people don't think about estate planning as worship, but it is. We get to do it because of the God we know that has chosen to make himself known to us, and how the gospel has restored us to know him and enjoy him. And so now this journey of estate planning gets to echo that. We do this because he has chosen to have an estate plan in which we got restored to him through his son's death and all of creation. We win, he wins, everything wins. How do we get to echo that in our own lives? Because there'll most likely be a day, unless he comes back sooner, that we're going to vacate. And we get to do some things with the people in our life and the stuff he's given us and be a part of what's going to happen to him. All right, next slide. There are 4 options that are common. There's one on your pamphlet that says community property. That's one of those things we're not going to talk about because it doesn't work in Oregon. So on the main presentation above us, it has these things. And we're going to unpack each of these. One of the options when it comes to estate planning, what to do when you die, is to do nothing. We'll discuss that. The other is joint tenancy with right of survivorship. The other, in addition to that, then, is to create a will. And we'll talk about some things that a will can do. And then the last is to create a revocable trust or revocable living trust. Okay? So we're going to look at these different choices or tools and see how they can be a part of your planning process. And what you'll find is, as we journey through this, the tools in some cases can be interconnected. It's not exclusively, I can only use this tool or I can only use this tool. There's often great benefit to using different tools in partnership to accomplish the bigger picture of what you'd like to see happen when you're gone. They all have pros and cons to them. Okay? Next slide, please. The first option, the first tool of doing nothing, it is the most popular option, period. And you know, that statistic of 70%, it doesn't matter if you're churched or unchurched, if you're redeemed or unredeemed, it makes no difference. The statistic's the same. Most people do nothing. And there can be a couple common reasons why they don't do any kind of planning. One is some people don't think they have anything, which everybody has something. Other people don't like the subject, and so they just rather avoid it. Some people are busy, which usually means that they haven't been wowed by the priorities and the blessing it is to make decisions. And usually those are kind of 3 common. So, how many of you in here are common and have done nothing? We're all in this together, right? We're here to figure it out together. That's where most people are at. Now, it doesn't mean that nothing's going to happen when you die. There is a plan. It's what the state of Oregon has in mind. It's just that may not be what you would have chosen if you designed it yourself. When you die, if you don't have a will, if you don't have a revocable living trust, if you don't have either of those things in place, if you don't have some of the other tools used with titling of assets, etc., you die in an intestate state. And what that means is a judge will determine who's going to raise your precious children. And for those of you that are grandparents, it means who will raise your grandchildren. And I say that because as those of you that are grandparents in the room or soon to be, you have a great voice of influence in the lives of your kids and the well-being of your grandchildren by taking the same information in. Okay? So if you don't have a will, in particular, or a revocable living will or trust, then in this case, the state's going to decide who's going to raise your kids. There's a good chance that it might get looked at, but it isn't going to be determinative like a will would. partially because wills need to be signed and typically notarized and witnesses, all that for the validity to be really good. It doesn't mean that that couldn't be considered, but it's not ironclad. So there's better ways to deal with it. In addition to determining the guardian of your little ones, you'll also find that the government gets to determine who gets your stuff. So the things you have. So the government will determine the relationship piece, and they'll determine who gets the stuff piece according to state laws. And that may or may not be what you would have chosen, but we don't have to just leave that up to circumstance and see what occurs later on. We get to be in on this and determine it ourselves if we choose to. The government will also determine who your personal representative is going to be. The classic term for that would be an executor. You guys have watched Perry Mason or other shows where somebody dies and there's an executor that reads a will. They will determine who that person is, and that's the person that makes the process of getting your kids and your stuff where they need to go according to state law possible. They're the ones that actually do the work of getting things where they need to go after you die. So the court would determine that. It is more pricey. Typically, they'll require that person to be bonded because they may or may not have the capacity or the ability to do the job well, and so it could be more costly if the state has to determine who's going to carry that out and having them have the appropriate kind of support by being bonded. And it says loss of control, but really that was your choice of control to do what you did and not do anything more than that. You chose to exercise limited control is the way I would choose to look at it, more than you've lost control. You chose, if you go this route, to say, this is what I'm going to do. And we make that choice. Nobody took it from you, so it's not a loss of. Next slide. Another option is joint tenancy, particularly with rider survivorship. This can be a good tool, but it shouldn't be like the absolute paramount, hey, this is the best tool. What that means is typically when you put two people on an account, the last one to die wins. So if two people are on an account with rider survivorship, first of all, they both own it the moment you put them both on it. We'll talk about the ramifications of that. But then whoever dies first doesn't get the full use of it. So the one that dies last gets everything that is in that account. Or they're titled on if it's a car or a home or whatever. It is a form of planning, and it has its place. But here's some things to think through. It is a form of property ownership. So if you put somebody on a bank account, checking or savings, or you put them on a car like that or a house, they actually own it when it's joint tenants with rider survivorship because it's already joint. It's just that whoever dies last gets the whole thing. That has ramifications. If you put somebody on an account now, they technically get ownership of it, and you may not have wanted that right now. They may be really trustworthy, and that could be okay, or they may be a little not trustworthy or have influencing relationships that could come into play, and they might deviate to doing what somebody's whispering in their ear to do. Or, not that this would happen to people that you would do this with, but if they got into a lawsuit because they had credit issues or they got in an accident, guess what? That's their asset, too, if you put them on the account. So it can get taken away. And normally we don't think through all that. We just like, hey, I put somebody on my account because I need them to pay my bills. And I've seen this a lot with people that are much more mature in their stages of life. I'm going to put my child on my bank account. They can take care of my bills if I have to go to the hospital. There are times that it may work. If it's a small checking account and it's not a big deal, that may be fine. But if they have the bulk of their wealth sitting in an account, all of a sudden they've given ownership to that one child. And that also means that they run the risk of disinheriting others. Because that person owns it, it supersedes anything a will is going to say. So if you put somebody on an account joint with rider survivorship, they already own it. It doesn't matter what your will says. They get it now, and when you die, they get the whole thing. It can create potentially a gift tax issue. We're allowed to give about $15,000 a year to somebody else without having to file a gift tax return. If there's more than that in the account, you need to report that. So it can create a little bit of extra paperwork. It also only works on each asset as you do it. It doesn't work as a blanket so that it affects everything you own. So if you have a lot of accounts and a lot of different assets, and you do this, and you want that to be your way that you decide to do your planning, you have to do that on every account. Put them on as joint tenants with right of survivorship. So it's a lot of extra work. It's not a blanket process of giving something away. And the thing with the disinheritance also is if most of your assets are in your bank account and you put somebody on it and you have a will that says, you really want everything to go 50-50, if that's where most of your stuff was, it already goes to that one person, and there may not be as much left to fund other people that you wanted to bless when you pass, or charities or whatnot. So you kind of need to figure out, is that really the best way to give somebody access to use my resources to pay my bills and stuff if I can't? And we'll talk about a better way in a little bit. It does have its place, like I mentioned, if it's a smaller account and it's just for like utilities or medical bills and small things, there's only a little bit in it, not everything. It could be a really easy way to let somebody take care of you if you need help. Any of you have any stories where you've been in this spot with somebody before yourself? Or okay. All right. Next slide. This is a pretty cool tool. Beneficiary designations. How many of you have a 401k or life insurance, or have ever? Okay. You have used this. When you signed up for those to begin with, you needed to list who you wanted it to go to when you die. So if you did it through an employer or you did it on your own, you've done this kind of a thing. This is a great form of planning. And again, this also supersedes a will. Anybody you put as a beneficiary or a contingent beneficiary, that's what will happen, irregardless of what your will says. Those two assets, particular, life insurance and retirement accounts, typically are not considered part of your estate when you pass. Okay? It's nice to use this tool and getting things where you want it to go. But like I mentioned earlier, you do need to think about it. Sometimes people that have had, maybe they're on their second marriage, I've run into situations where talking with them, they never took the first spouse off as the beneficiary. And not them so much, but maybe their second spouse told me, and you know what happened when my husband or wife died? Everything on that was in that account went to their first spouse, and I didn't see any of it. And that's not what they intended. They just didn't update it to reflect their current relationships in life. So these are things that you should update when major relationship changes happen. Usually people will list their spouse first and then their children as contingent beneficiaries, but you can even do stuff charitable as a beneficiary or contingent beneficiaries. You could name your church. You could name organizations in the community that pursue justice and mercy for the impoverished, whatnot. You can name whoever you want or whatever you want. And it's a great tool. I'll backtrack here for a minute because as we're talking about these tools, when meeting with people, I usually like them to take a look at the bucket, is what we call it. Let's discern what God's given you. And we'll look at all the cash that you have. We'll look at your marketable securities. We'll look at your retirement accounts, which are two different types of things. We'll look at your life insurance. We'll look at your real estate holdings and other significant personal assets. And we'll subtract out, maybe what you owe. And whatever's left is your bucket. That's what you get to be a part of making decisions when you're going to pass as to how you want that to flow out maybe to your children or grandchildren, others, and then organizations. This bucket gets to flow out, and we can use different tools to do that. Maybe it's this beneficiary designation. It may even be what we're going to look at here in a moment, a will. Could be a trust, but there's different tools to help this flow out to your kids and grandkids and others and organizations, and they work in concert with one another. All right? Like I said, that was most common. The next is a will. How many of you already have a will or are wanting to get a will? Okay. Wills are great tools. They're because of what you get to do with them. It's this legal document that will determine what happens to your property when you die, So the things that God's given you, and in what way and in what amount. We'll talk about that a little bit more here in a moment. In what way and what amounts. Because you get some say with stuff, which is pretty cool. It also is the place where you get to determine who is going to raise your children. Who's the guardian? This is where it should be spelled out. And that's pretty important. You can also create a trust for the benefit of your kids if you weren't around anymore to support them, so that it would help the guardians in taking care of them and bringing them up. And that's important to do. And we're going to talk about how to do that. And there's other kinds of trust that you can create that we're going to explore here for a few minutes. And you also get to decide who is going to make all that happen when you die. It's that executor or personal representative role. Those things are declared and made possible through what a will says. All right? Next. So the guardian standpoint. Who's going to take care of your kids, or if you're talking to your children, who's going to take care of your grandkids? Well, there's some things to think about in who you would want to raise them. And we all have some different values. We may have some same values, but how they're prioritized may be a little bit different from one family to another, either because of personal beliefs and or maybe the availability of people to actually fulfill those. So what we're going to talk about up here is kind of to help you maybe come to a good conclusion on who you might want to ask to raise those kids if you weren't around. And it may be a little bit different in how you evaluate that in your home versus people sitting next to you. Religious and moral beliefs are key to considering. You may know somebody that you want to raise your kids, but maybe they're pretty religious, or maybe they're very moral and they're not as gospel-oriented in how grace compels us to do right in the name of God in this world. And you may, I don't want that. Or you may say, hey, I want them to really help my kids know and choose to do the right things, and the motivation piece isn't as important. We're all in a different place with figuring that out. But those are the things you should think through, because where are they, and how is that going to play out in their pseudo-parenting of your little ones if you weren't around? How important is that to you? The co-guardians is another aspect. Sometimes it's good to have one person named, but it may be better if they're paired with somebody else. For example, in our family, now my kids are much older now. One of them doesn't even work for. But years ago, we had named my mom and dad. Now, it was an and/or thing. But I'll tell you, as my mom got older, her ability to be a guardian, it diminished. She couldn't do it well. So if my dad passed first, there is no way it would have been appropriate for her to bear the full brunt of joy of raising our kids. She couldn't do it well. She needed it to be an and thing. So you can phrase it so it's an and/or it's an and where it has to be a partnership. But you want to think through that. If you name two people, is the one of those two going to do okay without the other around? Maybe for temperament, maybe for ability or capacity reasons, whatever it is. But really want to think through that. If one of them is key, like if it's a wife of a couple that you know could raise the kids irregardless of whether the husband was around or not, you could put her on as the guardian and maybe not him. That's possible, because you know that if she wasn't around, it would not be a good fit for him for whatever reason. But think through those things when you're making decisions. Things like maturity, experience, temperament, patience, stamina, all that. Which also brings to mind, if you name somebody and you've got wee little ones, and let's say who you name is 70 years old and you have 2-year-old, how long are they going to be able to fill that role of guardian? They may only be able to fulfill that for maybe another 3 to 5 years before their capacity diminishes, and they're not going to want to chase a 7-year-old around. Thinking through that, you can name them, but no, you need to come back and revisit and adjust that in a few years depending upon the circumstances. Other things to consider in determining who might be a guardian are lifestyle, financial, social upbringing, a joke of wealth, redneck versus cultured, all these things. And I would say sometimes people put a lot of value on stuff. Sometimes people put a lot of value on being thrifty, and neither one in an absolute sense is healthy. We may lean one way or another, but we need to think about how they are going to influence the upbringing of our kids. I've known people that get upset over other people cooking hot dogs in the oven because that's a waste of electricity. Do you want your kids to experience that kind of scrooginess? And yet on the other side, people are like, hey, if we're going to buy anything, it has to be from the mall because it's got to be brand name. Do you want that to be an issue? Do you want the extravagance, even if they handle things well, if they're not going to help the kids understand how grace compels you to make decisions? If they have a lot, is that going to fit well for your child's temperament? You need to think through some of that. The redneck versus cultured. Years ago when we lived in the Portland, Vancouver area, the first church that we pastored was in Northeast Oregon, in a little rural community that did not even have a stoplight. We went from city to literally redneck. This community would not embrace anybody, even if they had lived there 30 years, unless they had been born there. They were always considered an outsider. They had some very interesting ways of doing things. And from the standpoint of our kids already having some exposure to a wide variety of ethnicities and cultures, that was not going to happen in a place like that. And most people that live in that area, they're very conservative, but they're also more narrow-minded and day-to-day in their thinking. Because that's just how you tend to work and function as day-to-day. When you don't have as much, you don't look as far ahead. It's not bad, it's just different. We didn't want our kids to be in that culture. Number one, they'd never be accepted enough. Number two, they were used to different experiences of more variety, and they wanted them to have more than just, steak and potatoes and white bread. We wanted them to be around multi-ethnic opportunities. So we wouldn't have left them with anybody there. But that's because of values that we have. That may not be the same for them. But some people are like, hey, if we could get our kids as far away from the city, that would be great. That would be so wonderful. We'd love to do that. You get to think through what matters for you. In addition, do they have children? This person that you would want to raise, your kids, do they have children? If they do, are they similar age? That also can be good or bad. It could be great because they have more companions. It could be bad because it may be something where there could be favoritism that comes into play. Or parents like, hey, I've only got so much. I got to kind of lean towards my kids, and I can't see them all equally. If there's a big age gap, that could be good or bad. It could be bad in that they don't connect with your kids. It could be good in that they really take them in and mentor them. Every family dynamic's different, but these are fun stuff to think through when thinking about who your kids might be raised by, and is that good or maybe not good for your situation. Geographic location, new school, new friends versus same old. Maybe a fresh start's really good. Maybe it's not. You think about students in their high school years. If they just lost both of their parents or the last of two living parents, do you want to rip them away from maybe what was a healthy social network and replant them for the couple years they have left of high school when they're already grieving the loss of their parents? Do you want them to have to deal with all the friends at the same time? Maybe that's part of the way God would provide support. Maybe it was really bad relationships and they needed a fresh start, and here's a chance to have a catalytic change in their life. Kind of play through those things and see. Maybe they're involved in some great programs that help accentuate some of the giftedness God put in their life, maybe the arts or athletics, and it's not as available where you would otherwise have them go to be raised. You process through those things. And then there's sometimes the fun in-law conversations where, it's like, there's no way our kids are going to live with your parents. And there's no way they're going to live with your parents. And then you make decisions, and this family goes, you're going to let them stay with them? Why not us? And you got to figure out how you're going to navigate all that, or if you even want to, and just avoid it and not name any of them. But you get to think through these kinds of things. And so what I usually suggest, because I've seen families really get so hung up on this, it's a year before they call me to finish the planning because they couldn't decide who. Name down what your values are. Prioritize them from 1 through whatever, and then weigh them out. We're thinking of Bob and Mary. Bob and Mary, they're grace-based. They're all about the gospel. So, and that's the most important to us. But, they don't have any of the other ones on the list that we want. And then you say, well, this other family, it's Ted and Sue. They don't have the same faith we do, but they've got the other 5 things on the list. And then you can kind of weigh those out as you pray through them, discuss them together, and ask the people, what would they do? Would they be okay with being named to raise your kids It could be something where it's only a couple years, or it could be a long time if you got wee little ones. And then you can make a decision as to who would best be that person or people that you'd like to shape and mold those children into young adults that launch well. So these are good things to think through. And you can name that person in your will. That's where you want to do it, or people. Next. So you're not leaving the brunt of resource obligation on the guardians for raising these kids. You can help provide the guardian with the resources and some for the raising of the kids, or if you're talking to your children, the grandchildren. You could even create one of these. If you're a grandparent, you can create a grandchildren's trust to do some of the same things. So a children's trust or a grandchildren's trust would be created by the will when the second spouse dies. We're going to assume that. Typically, when the first spouse dies, you're probably going to say in your will that how you'd like everything to go to your spouse so that they can be taken care of. So we're going to, for default, talk about what all this is when the second of you dies. Is that fair? Not that you couldn't do something different, but just for commonality for most people. So that was the case in naming the guardian. It's if there's no spouses left. In the case where both spouses are now gone, the will could say that at the second to die, you want to create this family children's trust or a family grandchildren's trust, and it would provide for the children that are named in some of these different ways. It can provide for health, education, maintenance, and support. You see that HEMS up there? Kind of just below the middle of the page. HEMS stands for health, education, maintenance, and support. So this trust, you could have dollars go into, and it would pay those kinds of expenses out as you set it up to do so. And so it would literally supplement the guardian having to provide the resources for health, education, maintenance, and support. This trust could put those dollars into play for the children until whatever age you set. Some people say, okay, well, I want that to be available for my kids or my grandkids through age 18. And then they can do whatever they want with whatever's left. Other people are like, there is no way I want the kids to have free access at 18. I have seen it both ways. I've seen some parents say, you know what, by 18, whatever they do, that's between them and God. And I've seen other people go, no, we're going to continue to try to have some input in this until they're like 30. So you may say, okay, well, we're going to let them have health, education, maintenance, and support distributions through age, say, 21. Maybe that allows them to have some schooling. They can go to college if they want, or it could be available if they do a trade school, or just to launch into the world and they're going to go work at Starbucks, but they have this to kind of help them get going. And if there's multiple children, let's say one's 2 years younger, you could say when the youngest one reaches age 21, which means the older one would be how old? 23. I'm seeing if you guys are awake. I'm putting you to sleep because you didn't track on that. So let's say that there's 2 years difference. When the youngest one reaches 21, everything can be distributed between the two of them. So that means the other one's 23. So there's been health, education, maintenance, and support for both of them. The older one got it to 21, and then for 2 years had nothing. And when the youngest one has completed their 21st year or their 20th year, how you set it up, whatever's left in that trust can be shared equally between the two of them. So you've provided for health, education, maintenance, and support, equal opportunity through the same ages, and then when that season is done, you can have the kids sharing it for whatever. Or you could set it farther out. The main thing with all of these that we're talking about is you have such freedom to explore and design what makes the most sense for your relationships with the things that God's given you. I'm throwing ideas that kind of help lift your heads and draw your eyes out to a farther horizon than maybe you're already focused on. But these kinds of trust are great because they allow the trust to specifically make distributions just for those things, which is controlled and encourages the kids to grow and launch well. And then whatever's left they can use for things that hopefully they're mature enough to do well with at a later age. And again, you can do this for your kids, or you can set this up for your grandkids. Now, in that case, it can fund college. It could fund their rent. It could fund their utilities. It could help fund their mortgage payment because there's support in there as well. Any health stuff, if there's some kind of special camp that they want to go to that helps maybe with some kind of an endeavor in their growth in life, whatever. It's good for all that. So it's a way to provide. This kind of a trust may work, as the will creates it when the second spouse dies, but it could be worked with your beneficiary designations on a life insurance policy or even a retirement account. Now I say that because if you just name your kids as a contingent beneficiary in one of those two things, what happens when they turn 18? They have total access to it. If it's life insurance, it will go into Uniform Gift to Minors account, most likely, until they're 18. But once they're 18, they can take it out of the account. If it's a retirement account, it will go into their name, and it will be stretched out over their life distribution. That once they're 18, they can cash it in and pay the penalty and do whatever they want with it. Let's say Bob and Mary Smith say, we want to create a family children's trust. So it's the Bob and Mary Smith Family Children's Trust when the second spouse dies. They put that trust that the will says will be created, the second death, as a contingent beneficiary on their life insurance. So Bob has life insurance, Mary has life insurance. So what happens is they give it to one another, but if they're both dead, who it goes to is the Bob and Mary Smith Family Children's Trust. So then that life insurance will fund that family children's trust and be distributed according to the way that you designed it to, or they designed it to, for the years that they want the kids to be blessed. It will make it run through your estate, which may subject it to some estate tax. Not a lot, but it's the only way you can have input on how those dollars are going to be used for the benefit of the kids. Otherwise, it's a free-for-all when they're 18. And that may not be the best thing. In most cases, it's not. So you see how those two tools work together, using beneficiary designations and a will to get resources in a constructive way to bless your kids or grandkids with more detail than otherwise you would be able to do. More definition. Okay? All right. Next. Now, there are other trusts that your will can create also. Wills are really cool. They're great tools. Great tools. You can create trust if you want to benefit somebody that has special needs. You want to not give it to them directly. If somebody's receiving, say, Social Security because they're disabled, if you give them more than $2,000 as an inheritance in a year, you will disqualify them from receiving public benefits. You don't want to do that. They need that money. So the solution would be, if you know you're going to leave money to an heir that has special needs and they're going to be on Social Security and get public benefits, you would want, through your will, to create a special needs trust for that individual. That trust will then be able to be available to make disbursements for anything above and beyond the basic necessities of life. So if they need to buy a car, if they want to take a trip to Hawaii or Disneyland, it's the stuff above and beyond what public assistance is designed for, the necessities of life. So you can make it available for them in a way that won't cut them off from their consistent source of income. Because unless it's some huge gift that could last them forever and ever, you run the risk of helping them in the short term and messing them up for the long term. So that's worth knowing. And that's one of the ways that you can take care of them without messing them up. Something else that your will could create as far as a trust would be a spendthrift trust. That's for somebody that you want to bless, that maybe is credit challenged. Maybe they use a lot of money by maybe debt standards and bankruptcy could happen. Well, if you put it into a spendthrift trust, it stays in the trust. It can't be lost through a bankruptcy filing. Or some of the other thing is maybe they have those really leechy friends. Like, oh, hey, I need a few bucks. Can you spot me $100 today? They can't just hand it out, so it doesn't run through their fingers like water if you put a spendthrift trust in place, because the trustee will only distribute the dollars the way you tell them to as long as that trust is in existence. So it may be health, education, maintenance, and support, missions trips, maybe an annual vacation for one. Whatever you say, the trustee will only put those dollars out for those reasons. Versus if you gave it to somebody that it's just like water running through their hands when you gave them money, it would be gone maybe within a few months or a year and there'd be nothing left. And you want to help them, right, as long as possible. The other is a spousal trust. If your spouse, is from your current marriage, and maybe you had a prior marriage, this could be a really good tool. In a situation where you're in a blended family, there are times, yes, believe it or not, that the current spouse and the kids from the prior marriage don't get along. It's like an epiphany. They just don't get along. And the current spouse, if you left everything to your current spouse, they wouldn't give anything to your kids from the prior marriage. They just, heck no. As a matter of fact, I'm going to give them to my children. Make it even more complicated and messy. Or if you gave them to your kids from your first marriage, they wouldn't take care of your current spouse. They don't care if they live under a bridge. Well, how do you work through those broken relationships with something good in mind for both? Spousal trust. The will could create a spousal trust that would put money into the trust and provide an income for your current spouse. So they could live off the income of the trust without deteriorating the principal. And then when your current spouse dies, whatever is in the trust can go to your children from your first marriage. That way you take care of both without leaving them to really mess the other one over. And you can create that through a will. Often I try to spend as much time as possible shepherding people to some kind of reconciliation so that maybe their will can do these things without trying to cut and paste, but it doesn't always work that way. And I have had couples that have been married, this is their second or third time, and the husband says, I want all these things to happen when I die with my stuff and bless these people, and the wife says, I want all this to happen, I want to bless these people with things when I die, and they're totally different wills. You guys aren't one. You're not one. You're missing the whole point of oneness here. Really, the last one that dies, if you leave whatever you leave to the other one, the last one that dies wins because their will is going to be what happens. Let's see if we can come together around the cross and work through this in a way that you guys can be doing this together, not seeing who's going to die first. You wonder who's going to get poison slipped in their tea, right? So there are ways to help navigate things where there can't be great resolution and still take care of multiple people when their relationships are in conflict. Spousal trust is one of them. And again, all this is what you can have a will create when you pass. Okay, next. So some common questions about wills. Number one is, can a will be revoked or changed? You bet. You bet. As far as it being revoked, typically when you do a new will, it has verbiage built into it that says it supersedes whatever was before it. So whatever was done before as a will is no good anymore, and the new one takes charge. I would recommend, though, that if you know where the old ones are, you destroy them. Because if they have some things in them that now are not possible, and somebody sees the old one and they find out they're not in the new one, they can make life really hard for your executor or trustee of your current will and whatever you want to have happen. And you might as well just destroy the old one. You can make changes. So let's say that you had certain people listed and you wanted to expand that. You could add them in through a codicil. It's the name of the form. Or you could take them out. That isn't always the best thing to do. For example, I had a gentleman that God did some great reconciliation between he and his wife and their son, who had rejected them and their faith, and they had excluded him from their will. Just didn't put him in it when they did it because of all the brokenness and mess. Well, as God restored them, he said, Kurt, I don't want to just add him in because he'll see that he wasn't part of it to begin with, and he didn't want that to be a point of contention and soreness when they weren't around later on. So they literally redid the will. So the codicil wasn't the best in that case. But yes, you can make changes. You can do a codicil to add or delete people. You can do a new will with a lot of changes, which will, in the verbiage, negate the old one. They're totally pliable. totally pliable. But typically you need to go back to the attorney that did it to make any of the changes to that will, or you need to find a new attorney which will do their own new will for you. Attorneys don't like to work on one another's legal documents because they stand behind what they draft. They're not going to stand behind the quality of another attorney's work. They pay malpractice insurance for their work, not for somebody else's. They want to be on the line for it. So typically you go back to whoever you work with, have a relationship, and allow them to help you make changes. Or if you work with somebody new, be prepared to redo all of it. They won't just do piecework on it. Okay? When should a will be reviewed? Well, there's a few answers to that question. One of them, I would say, is if there's major changes in your assets, and all of a sudden you get some ideas of maybe others that you'd like to take care of. You know, I talk about this bucket. You get to discern what God's given you, dream how you would love to share that if you were both gone right now, and the design how that's going to look. Well, if that changes, there may be more great things you can do. That's a time to review your will. Does this include all of the people we'd love to bless and all of the organizations? And maybe somebody that you wanted to give something to, their circumstances have changed. Maybe they've lost some mental capacity and they're receiving public assistance. Maybe you need to change. You don't want to give it outright. Maybe those you're going to receive something from you change, so you want to look at your will. Is this still good for where they're at? Those are things to consider. If you're aware of major law changes, that would be worth considering. For example, right now in Oregon, you have $1 million Oregon state estate tax exemption. If Oregon decides they want more money and they cut that down to $500,000 and you hear about that and that affects you, you want to review your will with somebody and make changes. For tax efficiency, always lead with your passions and then figure out the most efficient way to do it afterwards. Otherwise, I'd pull that out at least every 5 years and have a date with your spouse and go over it. Yeah, a date. Seriously. You two look at it, read it, say, hey, how does this reflect what we've been talking about? Does this still make sense? Are these the people we wanted to bless? Is this who we wanted to have our kids with? Have fun with it. You get to make these decisions. You're blessed to be able to have input in what's going to happen with your kids and the things God's given you. Dialogue around it. Become one over it. Hey, this is all good. Let's file it away. Or, ooh, we wanted to do something with Eastside Baptist Church, or we wanted to give to the Y. We didn't do that 5 years ago. Let's update this now. Good chance just every 5 years pull it out and look at it in case nothing in life's changed. If somebody that you had named in it is now dead, that may be a trigger to pull it out and review it. If your executor's gone off the deep end and they couldn't handle the job, maybe that's a reason to do it. Pull it out and change that and look at the rest of it. Those are some suggestions. How long is it valid? It's valid until roughly 9 to 12 months after you die, when probate's done most of the time. They don't expire. It's not like the milk in your fridge that you better get on drinking over the next couple of weeks. Wills last. They won't just get old and moldy and be worthless. Which is also why you want to make sure that they reflect your current passions and decisions, because if they don't, they're what will happen when you die, because they don't expire. Where should you keep it? As Oregonians, you guys are fortunate. Your executors are allowed to gain access to your safe deposit box when you die. That's pretty cool. Otherwise, I would say maybe your freezer and a Ziploc bag. They typically don't burn unless it's a serious blaze, and they'll be waterproof that way. The main thing is, if I were to summarize where do you keep it, it needs to be accessible to the executor who's got to execute it when you're gone. So wherever you have it, you need to let them know, and you need to make sure that they can get to it. Give them a key, give them the code, tell them where it is. If it's in a file cabinet at home, whatever it is, they need to know where it is so they can get a hold of it. That's a suggestion. In addition to that, I would also give them on a regular basis, this executor or personal representative, maybe every year, every 2 years, this is your call, a balance sheet. Let them know what your assets and liabilities are, who they're with, how much, how to get a hold of them, so that when they have to jump in and manage your estate, they're not trying to figure out what it is they're managing. Bless them. Make it easier. Don't send them on a wild goose chase. You can keep an updated copy with the actual will in addition to sharing that with them. I'd also share the will with them so that they know what they're going to do when you're gone, and it's not a surprise. There may be some things that you need to help them grasp and be okay with, and you can have gospel-centered discussions about, that you won't be around to do if you don't do it when they're alive. You want them to be good stewards of your intentions, so, bring them into it. Have coffee, have them over for dinner, whatever, and unpack it with them. It also would be good, as much as it's appropriate, to let your family and friends that are part of your plan know what you're thinking of doing. And organizations, hey, we passed. This is what we're intending to do. It's in the will. We used to be pretty private and kept all that secret, but I think it's good to help people get in on it in as best way possible from a discipleship standpoint, because you can help them understand things that God has touched you and given you a passion for that they may otherwise not be exposed to. Keep it about him, and you may find more willingness to share what you want to do with somebody even while you're alive. It should be a good thing. How much will it cost? Typically, there's some things that come in a package. There is a durable general power of attorney that we're going to talk about, a basic will that can have trust provisions, like for your kids or your grandkids or your spouse or special needs. Those are kind of basic. You can have those included in a will. All those documents, a will and a durable general power of attorney together, will probably cost you upwards of $1,000 for both you and your spouse to have those drafted in Oregon with a good, reputable attorney. You can easily go get some software for a lot less, but you don't always know what you should say and how to do it. And so the software isn't necessarily going to be there to help you through all that, and it's not going to necessarily be as up-to-date always as an attorney will help you maintain it. I'll give you some other input on how to get to that point. You do need to do what you are most capable of doing. And there are times where the software is feasible, and I can help bridge the gap to some point, as well as also help you with what you would want to bring to the attorney. Is my will good in other states? You bet. Your will is good in every state. You can die as a resident of any other state, and the will that you did in Oregon, it's good. It may not be best, but it's good. Think about it this way. If you guys end up moving into Washington, Washington has a $2 million state estate tax exemption per person instead of $1 million. That might affect some of your planning. If I were to come from Washington into Oregon, I probably would want to update my will if I had an estate that large. Because all of a sudden, I'm going to have tax ramifications to think through sooner than when I lived up north. And if we move to California, you definitely want to change it, because California is the worst state to go through probate with. It's very expensive. Worst state. Washington's the best, Oregon's second best, California's the worst. So when you move somewhere, your will is good. It just may not be most applicable with state laws at the time, and so you do want to update it. Okay? All right. Next. Do you guys want a quick, I want to refresh myself break for 5 minutes? No? Okay. Well, let's pound it out and finish it up then. Another tool is a revocable living trust. Have any of you ever heard of those? Okay. Yeah. They were very, very popular 10 to 15 years ago. They were very popular. They were very popular for several reasons, but it's a revocable living trust in that the key word there is revocable. You can put things in it and you can take things out of it. Your assets can go in and they can go out. Your bank accounts, your house, your cars, your stocks, your bonds. Put them in, you take them out. It's a revocable living trust in that typically a husband and wife would create one of these. So again, if it's Bob and Mary Smith, create the Bob and Mary Smith Revocable Living Trust. That would be the title that they would want to put on their bank account, their checking account, their savings account, put on their brokerage account. You title all your assets into it, the house, so that they now are the property of that revocable living trust. And Bob and Mary would be the trustees, which means that they manage those assets just like they did when it was in their own name. for their own benefit. So they would create it. They would be their own trustees. They would put all their stuff in it. Why would they do that? Well, the trustee standpoint's nice. It automatically allows the other one to basically manage all the stuff if one of them couldn't anymore. And you could even name an alternate trustee or two in case Bob and Mary weren't able to be trustee. So they actually have, if they had all their stuff in it and they had alternate trustees, those people could manage all of their resources. If Bob and Mary were incapacitated, they were in a coma, whatever was going on. So you have somebody to take care of your things when you weren't able to do that yourself. That's a benefit. Some people thought it was great to avoid taxes, particularly anything from a probate standpoint. Not so in Oregon anymore. Not so in Oregon anymore. People used to think you could avoid creditors because you avoid all of probate if you had one of these for the most part. You just put everything in it. Nobody needs to know what happens with your stuff or that you died because it's in this trust. Several years ago, creditors in Oregon got really tired of getting gypped. People were dying that owed money, rightfully, whether it was the government, whether it was utilities, whether it was finance companies, and they did some lobbying, and they got laws changed. So they do a modified probate now in Oregon for every single revocable living trust. So people can't avoid probate and skip out paying who they owe stuff to in Oregon anymore. And it's becoming so popular that other states are going to be adopting it. So that whole idea that we'll do a revocable living trust so we don't have to have this public, which probate is a public process, and therefore we don't have to necessarily pay all of the creditors, it doesn't work that way anymore. Which it really never should have, because if you owe somebody something, you ought to pay them anyways. Okay? So that benefit is not on the table anymore. It's gone. Next. The revocable living trust had benefits from a standpoint that, number one, you could name different trustees to manage all your stuff, even while you're alive, if you weren't able to do it anymore. But then they also would have the ability to get the assets where you want them to go when you die, because you would spell it out in the revocable living trust what you'd like to do. And if you happen to miss putting things in it, you could have what they call a pour-over will, which would cover all those other assets and pour them over into it after the fact, so that that document, that trust, could determine where things were going to go. People used to think it was avoiding probate, not anymore. The privacy isn't anymore. The taxes aren't anymore. The charitable giving, you could say that you wanted to give it to your church, you want to give it to the YMCA, the YWCA. You can do that through your will, too, or your beneficiary designations. But this was one of the reasons that people with these trusts had them and liked them. And because of the blended family issues like we talked about, these kinds of things could say, I want to do a spousal trust or whatnot. You could spell all that out when the second one dies in this kind of a document. But you can also do that with a will. What I would say is, unless you have more than $2 million in your estate, these probably aren't the best things for you to consider. If you have property, real estate in multiple states, it might be a good thing to consider. Because if you have a house, say in California, you have a vacation home, and you're an Oregon resident, when you die, that house in California has to go through probate in California and Oregon. If it's in the name of a trust, maybe a revocable living trust, it only has to go through Oregon, not California too. So it can be more beneficial for you. So that if you have properties in multiple states, this might be a good thing, or another kind of trust. If you have more than $2 million in your estate, this may be a good tool. But these cost about $5,000 to create. They're a little bit more than a will. And there are ways to do a lot of the same things for a lot less money than just using this tool. Next. So we've talked about trustees. Because in your will, if you create a grandchildren's trust or a family children's trust or a spousal trust or a special needs trust or even a revocable living trust, you have these trustees. Anytime you create a trust, you have to have a trustee. Why? Because you need somebody to administer the trust according to the terms that it's set out for. And it could be a really long-term commitment. You know, when you die, the executor that makes your will play out, it's a 9 to 12 month responsibility, typically. But a trustee could be on the line for years. Think about if you have 2-year-old kids and you create a children's trust. When the second person dies, that trustee may carry that from the children's age 2 until age 25 before everything's distributed. They could be doing this for a long time. So trustees, be aware that their responsibilities could stretch far out there in thinking about who that trustee is going to be. You might also realize some of these responsibilities that a trustee has to help determine who you might want your trustee to be. Because you have to have somebody take care of the trust. You can determine it, or there's some basic things depending upon state law that allows them to be compensated for their time. They also have the ability to hire, say, a tax person or an attorney or an investment, like a broker or whatnot, to manage the assets, to do the tax reporting. They get legal help, and that will come at the expense of the trust. It doesn't come out of their pocket. Okay? So they can hire people to do things well because they have to manage the property. So if it's real estate, if it's marketable securities, whatever that trust is holding, they have to manage it to accomplish the purpose that you have the trust for. If they have to have constant income to pay for kids' expenses, they need to think about that while also having some growth because they're going to have money available down the road for those kids when they go to college and launch out. So the trustee has those kinds of things to think about in managing those resources. And then they also have to make the distributions the way that you say you wanted them made. Health, education, maintenance, support, or missions trips, or whatever it is. If it's a spouse or it's a charities, whatever kind of trust it is, the trustee has to put those dollars out. And then they have to keep records of the distributions. So they got to manage it. They got to pay it out. They got to file annual tax returns. There's some work involved in it. So yes, there is compensation by default according to the way the state is and the way that they're typically written by an attorney, but you may want to do something other than that. They get to make tax decisions. Sometimes certain things are good to sell at one point, but it may be better not to sell it. It may be better to wait because of the amount of tax that it could create for the trust to pay, which would take away the value of the trust at that point. And maybe they can get help in figuring those things out. They also will be the ones that wrap up the trust at some point. When it's fulfilled the span of time that you designated for it to or the purpose, then they have to close it up some point down the road. So a trustee is a little bit more involved than an executor or a personal representative would be. You can have an individual trustee. You could have a corporate trustee. An individual trustee would be like any of us in this room. Typically, I would look for somebody that has the capacity and the ability. So maybe they're good administratively, maybe they're good financially, and they're not going to be totally falling to pieces when you die that will keep them from exercising those abilities. That makes sense? That's the capacity side. Maybe as you look through it, you're like, you know what? I think I want a corporate trustee. Corporate trustee would be an institution. It could be a bank. It could be a credit union. It could be a trust company. It could be a foundation like us. But you want to check around. Don't just name any of them. Find out what kinds of trust are they okay being trustee of, and what do they charge to do it. The reason I say that is some banks and credit unions won't touch a trust unless it has more than $1 million in it, and it has to be marketable securities. They won't touch real estate. So know what kind of assets they're comfortable with, know what kind of fees they charge. Check those things out. We do trustee work. We charge a 1.25% fee, but a lot of the other corporate trustees may charge 2% or more on the first $1 million, and then they may go down after that. Corporate trustees are nice because there's continuity. If a person dies, who's to say the next trustee is going to be the same? If it's a corporate trustee, staff may change, but the values and mission of a corporation can be consistent from one employee to the next. So there may be more longevity in hiring a corporate trustee. But if it's a small trust, that may not be a good thing to do. So you just kind of weigh it out, check it out, see if it makes sense or not. You may have somebody that you know is really good at things like that, and they'd love to take that on as a way just to honor you and do good. So you can have either one. Not necessarily. If your trust is going to be pretty labor intensive as far as dealing with things on a local scope, maybe that's not good. But technology-wise, as far as investment decisions and distributions and things like that, they don't have to be nearby. If you have a lot of real estate here, they may want to be close to that. Or they may decide to turn on and hire a property manager. But it just depends on what it is and what you want them to do. Distance may or may not be an issue nowadays. Okay? All right. Next. So before we talk about executors, which we'll naturally flow into, we'll take a quick moment to unpack what probate is. Probate is, by definition, a legal process for transferring property when an owner of the property dies. It also is a phase in which there's some determining of relationship as well, because if you have minors, that's where your guardians are determined. Its purpose is to provide an orderly transfer of property while protecting those who might have an interest in the property, including heirs, creditors, and government. So transfer from the deceased to where it should go while not gypping those that have a claim to it, heirs, government, creditors. Typically, and this is where we're going to kind of blend what an executor or personal representative is with this process of probate. When you die, your will should name that executor, the person that's going to make your will come true. When you die, they need to take your will and your death certificate. If it's a spouse, you can do this for your spouse. If it's when the second spouse dies, it's whoever else you name. And they need to go down to the local probate court for that county. A judge will look at the will and the death certificate. They'll look at the will and go, okay, this is good, I bless it. Or this is fraudulent. But if they bless it, they say, okay, executor, do your thing. You are empowered. Go for it. That's when they need to know what they're working with. What is this estate? What are the assets? What are liabilities? Who are the people that the deceased wants to bless, or the organizations? So that's why I'm saying keep them in the know on what you have and who you owe to and how to get a hold of them, because otherwise they're going to be scrounging through your stuff. And that may not be the best thing for them to do. It can be time-consuming. It can be difficult if they were really connected with you and you just died. Make it as easy as possible. Let them know what you have, where it is, how to get a hold of it, or who to get a hold of to get things done. Okay? So they're going to look at what you have. They're going to determine what you owe. Then you send letters out to creditors, let them know they need to make their claims. After the creditors do that, then they can take the assets that are still there and distribute them out according to how the will says you want it done. You know, if you wanted to bless your kids, you wanted to create this trust, they would create the trust. They'd hire the trustee. They'd put the assets in the trust. That's what the executor does. So those people that are going to come in as trustees can get going. The assets can be there for them to do what they're going to do. Other assets that you have, if you wanted to be shared equally amongst your children, they would make sure that the kids had a chance to come grab some personal things like that, etc. Whatever the kids didn't want, then the executor needs to hold an estate sale, maybe give whatever cash is there distributed according to how you wanted your estate to be distributed. Whatever doesn't sell, they can call the ARC to come pick up, take it away, so there's nothing left, right? All the creditors have been paid, all the heirs have received theirs. There's nothing left. And then they file an estate tax return at the end of that 9 to 12 months with the government, and they're finally done. They fulfilled their role as executor. We've gone through that probate process of proving whose things those things are going to be and who's going to be guardian. Okay? There's some small streamlined probate process if people have less than $10,000 or whatnot. There's some really small, minuscule processes they can go through. They're less cumbersome. Otherwise, typically there's going to be something to go through. It may not be as complicated if there's not as much. But people can make it complicated. Heirs can make things complicated if they fight over stuff. I'm not sure how much instruction they give, but there are some really good resources online out there I know in Washington I found some great websites that are like, hey, these are the things that you need to do along these ways. These are the costs that you're going to have. And just kind of help educate, that executor so it's not totally foreign to them. They can also contact an attorney at the expense of the estate if they want. But there's enough information out there that they can typically figure it out and work through it. They don't always have to be from the area either because of technology to execute all this. They could be the state over or whatnot. Well, for example, I don't know the specific amount of time in Oregon, but in Washington, that window for creditors to make claims, if you send a letter out in Washington, they have 4 months and the door closes. If you don't send the letters to the creditor, they have 2 years to come back against the estate or the heirs. That could be a difference between the state. The estate tax exemption for Oregon is $1 million. Washington, it's $2 million. So the amount of the estate that would be subject to tax that would be determined through the probate process, it hits home closer here in Oregon than it does in Washington for people. The two states are very similar in a lot of other ways. They're very inexpensive, and they're very easy processes. They're the two easiest states in the entire country to go through. If you go one state south, you just landed in the worst. They charge 3% of the estate in California just for probate cost. The state gets that. Crazy down there. Yeah. It's arduous. It's not a good thing down there. So, as Oregon residents, and if you ever move up north, good places to die. All right, next. We just walked through that. Next. We condensed that in there. Next. Okay, so here's an idea. Again, in all of this, you got a lot of data, but again, let's come back to the motivation in all this. You have all been radically blessed by God, and had nothing to do with you earning it. He's that kind of God. He's good and he's generous. We get to echo that as worship for receiving that and making these decisions. So as we start thinking through the bucket of all this that he's given us and the relationships, and we say, hey, I'd love to echo that. Maybe I've put my time in. Maybe I've put a lot of time in here at Eastside, right? But if you're like me, I'm worth more dead than alive. Right? My life insurance is more resource than I could possibly give to anybody right now. So I'm going to tell my wife, I need to die first. You'll be happy. So I know they don't. I just try to make it encouraging, right? You're set, baby, when I die. You go on that trip I can't take you on. No. But you kind of think through things from the standpoint of, well, I've put my time in here. I'd love the resources to follow that relationship when I pass. Money should always follow a relationship because in theory it actually does. You get down to the core relationships, our stuff follows it. Whether it's all about us, it's all about him, or it's all about somebody or something else. Here's our chance in planning to say, look, if I were gone today, or in a spousal situation, when the second one dies, if we were gone today, and let's say you add up your life insurance, your retirement accounts, your real estate, all of a sudden there's $500,000. Who would you love to walk around and just love to bless you? Wouldn't that be fun? Oh, here. I've been down at the school, and I've been serving side by side. I want to bless this ministry for the kids if we were all gone right now. Let's do that. Think from that vantage point, and you're going to find that there's your children, but you're also going to realize there's nothing that says you have to give it all to your kids. You probably shouldn't. You want to help them, but God's also given you relationships beyond that. And as long as they can be reared well, maybe there's other resources that are left that you could do really great things with unto his glory in the community. So you start figuring, okay, well, I want to do this and I want to do that. And then maybe you're like, well, I want my kids to have this, but I also want this. And if I had more, I could do both. Sometimes just in the way that it flows out, you could accomplish a lot. This is one idea. If you had a couple $100,000 and you wanted to bless your kids, maybe they're younger and you need to have those resources to help them get through school, but you also wanted to do something for an organization that your heart has really been beating for and you've been serving at. You could do a give it twice kind of a plan. What that means is $200,000 goes into this trust. It takes a lot longer nowadays because interest rates are lower, but the income off of that trust would pay out to the children for however long it took to equal the original investment in that trust when you died. At today's rates, it may take 20 years to pay out enough earnings to equal what originally went into that trust account. But then when that happens, when what gets paid out is equal to what first went in, then what first went in can be released to a charity of your choice. So you can bless both. It takes a little while, but you bless both. So if you just give it to one, it's not going to go anywhere else but to the one, charity or the kids. That could be flipped. Some parents look at their kids and they realize, you know what, where they're at in life, they're actually going to need that more in retirement than they do now. Maybe they're in their young years and they're generating great wages and they're doing really well. They don't need more income. They're fine. But we know when they get older they may need it. So maybe they flip this and they let the income flow out to a charity for maybe the next 20 years. And then that original balance goes to their kids when they're older. Maybe they're on fixed income. You could do both. There's ways to help those resources fuel your passions that God has stoked in your life. The main thing is to think through them and not just go to default presuppositions about, I have to leave everything to my children. No. You don't have to. You need to do what God leads you to do that's reasonable, but there's so many other things, especially when you start thinking about all that God gives you. How many of your kids, if you add in your life insurance through work, and you got $500,000, and your house is a couple $100,000, and you got a retirement account, all of a sudden maybe you're close to $1 million. Your kids need $1 million? And often this is the big, oh, no, actually they don't. Or my kids don't need $300,000. They're in their 20s and they don't need that much. Okay, well, what is appropriate? And then where else would you love to bless? And let's take a look and think through it. Not just, I got to do this or I got to do that. Let's think through it and see how it compels you. Lay all that out, and that's how the plan gets to unfold in your design process. Typical rule of thumb, though, is if you have less than $100,000, it's probably not a good idea to put it in a trust because the cost of the trust will eat up too much of the principal balance. It's just not efficient. So if there's less than $100,000, give it outright or figure out another way. Some things, like if somebody has special needs, there are sometimes pooled funds where they'll take the funds for a bunch of recipients and manage them collectively for people that have special needs. And there's some that are in the community or state-sponsored. That's a way to still do something without doing it inefficiently. Kind of like a community foundation. But those are the things that you get to discern through some planning processes in the journey. And I'll unpack that more. Mm-hmm. There's nothing that will guarantee its preservation. But the trustee of any kind of a trust like that is to manage those resources to fulfill the purpose of the trust. That should determine what they're investing in and when. Maybe it's income for a long time, and then all of a sudden, it could go into a growth mode. Or it was a growth mode, and all of a sudden it's needed. It needs to be ratcheted down more to an income mode, or a mix of the two along the way. They need to make that determination. So usually there's latitude as long as they're fulfilling the purpose of being, in a trust. But yeah, now if they're mismanaging it, typically that's where a beneficiary will get an attorney to go after the trustee because they're not doing their job well. And you go through the court to do that. Okay. Next. We're going to leave it on this slide and talk about a couple other things. So we have spent the bulk of our time, in the last hour and 35 minutes, discussing what we get to do when we're gone because of what God has done for us through Christ and the tools that we can bring in to make these assets flow to our children and grandchildren and others and organizations. All that's for when we die. there are some things that we need to be thinking about while we're on this side. There's stewardship that needs to happen while we're alive, and we're not always in a place to call the shots. But we're still here. So this is the stewardship when we die of relationships and stuff, but there's also stewardship of relationships and things while we're here. And maybe we're not able to make decisions. How do we express that and get things stewarded well when we aren't the ones that are able to do it? Well, there's two things to discuss. One of them is personal stewardship. Yourself, physically. What if you're in a coma and you can't communicate? What do you want done related to life support? What do you want done as far as quality of care and those things? In Oregon, you need to have an advance directive. The state has a website. You can get a booklet. It allows you to think through some things. And at the back of the booklet is the actual form. I would order one of those and complete that as it walks you through it. It allows you to give voice to what life support means for you when you want it, when you don't want it. A few other kinds of things that you want to be able to have some voice to. You are creating conversation over a subject for a day that may come when you can't communicate at all. And other people need to know what you would have wanted because it gives them clarity. It can promote peace interpersonally between them and others. And that's going to also bless them with great confidence. We use a different kind of form in Washington, but the story is still applicable. I've had a guy share with me and other stories that are very similar where there was this kind of discernment for somebody in their life, and they put something together that gave direction. And when they were in a coma, a son was able to take care of his mom according to her wishes based on this kind of a document. The other siblings were like, why are we doing this? I don't like this. He's like, look, Mom already spelled out what she wanted done here. She spelled out what life support looks like and when she wanted it, when she didn't want it. Oh, okay. And it promoted peace between the siblings because they knew what Mom wanted, what Mom otherwise couldn't communicate. It's good for them. It's good for that care. You're going ahead to create conversation when you're not going to be able to maybe even move a thumb or bat an eyelash or say anything. Bless them with that. So in Oregon, it's an advance directive. You can pull it up on Bing, or you can do a Google search, order the workbook, walk through it, think through it, pray through it, and then complete it as it says to in the presence of, I think it's a couple witnesses and maybe even a notary. Okay? That's the stewardship of you. But you also have the stewardship of all your stuff when you're here, but you can't make decisions. A durable general power of attorney is an excellent tool. Unless you have that revocable living trust and all of your stuff in it, and trustees to act and manage your things, durable general power of attorney is an awesome tool, which you can even name the guardian of your children if you are not able to take care of them. And the power of attorney that you nominate could put your children in that person or person's care when you're not able to do so. It also gives them the ability to pretty much, you understand the scope of this, manage everything you own. They can buy and sell your house. They can make decisions with your retirement accounts, your life insurance, your utility bills. There's even HIPAA disclosures and the ones that are done well, so they can interact and do medical bills. Totally thorough. You're giving that power to somebody when you have a durable general power of attorney that is tremendous, and there's a lot of responsibility with it. They are supposed to exercise it as if they were you for your benefit, but that has not kept people from doing really bad things with them. Okay? So you need to know the person. You need to be confident of their character and of the influences in their life before you would name somebody. Typically a spouse will name a spouse, and then they'll name the backups afterwards. But they're excellent tools because there's a high likelihood that we could be in a state, maybe we had surgery, we didn't recover quickly right away, some other catastrophe happened, and we're still alive. You don't want to put the people that are depending on you in the place of you getting a guardianship set up for you as an adult. It involves the court, it involves attorneys, it involves doctors. It's painful, it's expensive, and it's not necessary to have you deemed incapacitated. You could easily have a durable general power of attorney in place for somebody to manage your stuff and get a guardian to take care of your children if you are not able to function. It's up to you. I know from our standpoint, we think it's pretty cool if you just have one, because people don't fight that way. You know how well they hum with each other and how well they could function in a stress moment like that. But typically having one do it and not do a co-deal is a good idea, more often than not. We used to function in those roles for people that didn't have any other relationships. We don't do it anymore because we can't do it well enough in everything else we do. And we stop refusing any kind of a co-assignment with children and stuff because it doesn't work well most of the time. Okay. All right. Like I said, we've discussed the stewardship of your stuff and your relationships when you're dead. Wills, revocable living trust, beneficiary designations, joint tenants with right of survivorship, some partnership of those different tools to disperse what God's given you to his glory and the good of others when you're gone. That has no bearing on your stuff when you're alive. So that's why the stewardship of self, you look into the Oregon Advanced Directive, and then look into a durable general power of attorney for all of your stuff and maybe taking care of minors when you're alive, but you can't. So they covered stewardship on that side, giving somebody else the ability to do that. At this point, you kind of look at, well, where do I go from here? You just dumped all this on me. How does it work out in my life and in our situation, and where do we go from here? Well, you could easily go run and talk to an attorney. You could try to just navigate it on your own. What we will offer to do for you, and there's no cost. People have given gifts to us so that we can be alongside you in the journey and help you with this, is if you want me to follow with you and sit down with you and help you discern what you have, dream what you'd like to do with it, and start designing how it will flow out to bless others to the glory of God, I'm glad to do that with you. We usually start the journey, it's about an hour and a half to start it, to sit down, and then most of the time people will have homework to pray about, think through, talk through, to execute those points before we can take some of the final steps in putting all that together. So I use a data sheet and I summarize it so that it can be handed off to an attorney to draft papers. And then they fine-tune it because they're really smart at that stuff, and that's what they get paid the big bucks for. But by doing all this with you, it should in theory save several hours of doing that with an attorney. Number one, that they're going to charge you for by the hour. And they charge a lot. But also, they're not going to look at the stewardship perspective from the basis of grace and shepherd you through it like I would love to do. So you can have their technical expertise in partnership with your passions in a way that you may miss out by just sitting in a law office. If you decide you want to plug it into software, then you know a lot more than you did if you just sat down and started trying it on your own. Like I said, there's no cost. We do this because people have given gifts to the foundation, so we can be about this as ministry. Plain and simple as that. If in the course of your planning, though, you're like, hey, we want the foundation to be the trustee of this trust, or we want to give a gift so that the foundation has resources to continue to bless others, if that's a natural outflow of your planning, we have an attorney that will do a will for a husband and a wife and a durable general power of attorney for about $400. Now, don't ever plan to get the discount by saying, we're going to give you money, or we want you to be trustee, because you're going to save a few $100s on the front end, but it's going to cost thousands of dollars from going where your heart really wanted it to go later on. So if it's part of your natural planning, somebody has said, we want to help facilitate that by reducing the cost of the legal work. Okay? And that's an option for you. But nonetheless, to get you to a point of being able to get your documents done can help you through that journey, begin it, get you ready to have it put together in a draft format, and that ought to help you navigate it, but also probably save you some money from sitting down with a professional that's going to charge you to do it from an attorney standpoint.